Yeah, I think it's a matter of, do you trust your lawyer? If you trust your lawyer, then you probably take their advice.
But in terms of solicitors then, it sounds like, from what you've seen, there's not necessarily a correlation between the price and the skill. Something happens to people where when they're writing an email or behind a computer screen, they really talk in a different way.
Very effective young lawyers out there who are extremely efficient, very low hourly rate, and will get the job done very well.
I actually look at the court system not necessarily there to resolve problems, but it's more of a punishment, partially. I think part of it is a punishment for having a problem, which you're unable to resolve with that person directly. And the punishment comes in the form of using up a lot of your time and a lot of legal costs. Because what really ends up happening is, if you look at it from the court's perspective, why are you here? You can't resolve this with each other. You're both copying it in terms of the time and money you're spending. Copying that should give you an incentive to talk to the other person and see if you can resolve it.
I think that depends on the two individuals involved. A lot of litigation is emotionally driven, and once people, become angry or hurt or whatever other emotion they may be driven by, they become a little bit irrational, and they don't necessarily think of the big picture. They're more just driven by, the heat of their emotion. And that makes it difficult for people to think rationally and resolve conflict that they have with other people.
Do you think there are people who get so emotionally tied up in their case that they'll ruin themselves just to get at the other person?
Absolutely. And it becomes a bit of a disease for some people. They become so, I guess, caught up emotionally in the conflict that they're involved in, and it becomes a little bit addictive to them, I think, too. There are serial litigators around. These people actually enjoy litigating, being in court, and causing grief for people they may not like, or people they may not agree with.
Do you consider a serial litigant to be a good client from a business point of view?
I'd say there'd be a lot of solicitors that'd be happy to have that type of client, yes.
I wouldn't think so.
Why is that, Adam?
I think that a person like that would turn on you eventually.
Quite possibly, but I guess the way a solicitor may look at that is that they'll, make a lot of fees before that happens, and that will be enough for that potential risk down the track. And I'm sure they can, work out a way to get out of it without too much damage. I guess that would be a plan that you'd want to have up front if you were aware of that potential outcome.
One thing I did notice about the legal profession compared with accounting, because I worked in both types of firms. In accounting, there's a much higher predisposition towards discounting and trying to give good fee agreements. And in law, there's a very low disposition towards giving discounts or reducing fees or anything like that. Have you noticed that?
I don't have a lot of experience in the accounting area, so it's difficult for me to compare. I do know some firms of solicitors that regularly give discounts to their clients, as a matter of goodwill. Usually, probably in the vicinity of 10% or less, but it's still something that some solicitors do. And then some solicitors are very adamant that their clients should pay every single cent of their tax invoices because they believe they've done the work and they deserve to be paid.
So if we categorise lawyers then, this is just for the man on the street or the lady on the street. I'll describe some categories, but I know you know more, so you can tell me. But I would say there are people who sort of are not really... At the lower end, there are people who are probably not that religious and recording their time and fees, who probably end up being cheaper or doing fixed fees which end up being cheaper, but they might compensate for that by doing a bit less work. There are people who bill, say, normally, I suppose, they just keep sort of a timesheet. But there are people who would be at the extreme end of collecting everything. They'd be the people who might charge you for photocopying and printing and things like that. And they tend to be very sharp in making sure, that every possible dollar is earned. I mean, those are probably three very broad categories that represents the spectrum as far as I know. But what would you say to that?
I'd agree that different solicitors charge in different ways. In my experience, the type of solicitor that probably doesn't record his or her work will either charge you way too much or probably charge you way too little. They don't tend to have a realistic grasp on how much something actually should be costing, and they do tend to vary quite widely, with their final invoices. And the solicitor that keeps religious time records, I think that's a fair deal, and I think that's a good way to work. And I guess most solicitors would fall into that category. And then there are some solicitors, as you say, that record every single cent that they possibly could record in their invoices. And whilst I may not be a fan of that type of costing, at the end of the day, it's a business, as I say, and they've got staff to pay, they've got insurance to pay, they've got other overheads, they've got rent and various, I guess insurance type of fees, and they may be in a partnership where they need to answer to other partners for their own, small part of that partnership. And that's the way they do it. I guess that comes down to an individual personality approach to being a solicitor. I've always kept time records when I've been a solicitor. I, in my own work, regularly give discounts to clients. Not too sure why, but I do. A lot of clients ask, can you, charge me less than the work? And it's difficult to say no. Perhaps if I said no, they'd just pay me anyway. Perhaps I'm a sucker, I don't know. But, people pay a lot of money for solicitors, and I sort of think if you give them a small discount, they'll be happy. You're still getting paid for your work. You may not make quite as much. But, I'm still happy and they're happy, so everyone's happy. And I think that's a good way to be.
Okay. Well, we've discussed counsel, and I think you've made... Your observation is that there is a correlation between skill and pricing. Now, I will ask you this question. Do you think that the same is the case for solicitors?
I'd say not so much. I find solicitors perhaps charge where they feel comfortable charging, which may range from a few $100s an hour to several $100s an hour, and they charge depending on the market that their practice is operating in. So if your practice predominantly involves mum and pop type of clients, you might charge a lot less than if your practice predominantly involves companies, possibly ASX listed companies, possibly insurance companies by way of example. If a solicitor has high volume turnover from a client, such as an insurer, then they'll charge less money because that's what the insurer expects. They're getting a high volume of work from that client, so they're willing to discount that work. And then, you've got bigger practices. They have more overheads, they have more staff, support staff, they're paying high rents in the city. They really need to charge more money in order to cover all those additional costs. As another person maybe just practicing out of a small office in the suburbs, they can probably charge a lot less money because they don't have the overheads. So I think there's a lot of very skillful practical solicitors that charge less money. And I think overall, if you charge more, you probably have more experience and you're probably better, but it probably, to me, the variance is not as great with solicitors as it is with counsel.
Okay. What's the highest solicitor rate you've ever seen?
I've seen up to about, close to $1,000 an hour. Again, mainly people or law firms with large commercial clients will be charging up in that department, and that would correlate with your senior counsel charging at $20,000 a day, because they're dealing with big money. And
Well, $1,000 an hour is less than $20,000 a day.
it is. Well, senior counsel, proportionally will be charging more than, a very senior lawyer. You have to understand that senior counsel's working by himself. He might have some support some research assistants helping him.
Or her.
Or her. And the solicitor charging out, let's say, $1,000 an hour, he or she is overseeing a team of other solicitors that are doing work, and they're more than likely, going to be a partner or perhaps a consultant charging that sort of money. And they have a team of solicitors, and so they make their money or their extra money from their team of solicitors they have working underneath them, be they senior associates or solicitors. Traditionally speaking, they don't charge as much because of that reason.
So I think in terms of barristers, your perspective is that a barrister who's a senior counsel is the best, and that there's a correlation between fees and the charge and the skill, and that I think for someone just an ordinary person, they could probably work that out. But in terms of solicitors, then it sounds like, from what you've seen, there is not necessarily a correlation between the price and the skill. There are a lot of other factors and things coming into play.
Absolutely. I think the price, I guess, almost correlates a bit with perhaps the size of the firm, the type of work that the firm does, and the type of client that the firm has. There are a lot of wonderful solicitors out there that are charging $400 an hour. And if I personally needed a solicitor, I'd be quite happy to go with them, because I know they'll give me good service and they won't overcharge me, and they'll do a good job. Just because someone charges you, $1,000 an hour doesn't mean they're going to do a better job than someone that charges $400 an hour.
Let's talk about the workflow then, because obviously the costs of any matter includes the solicitor's time, it includes the barrister's time. How much overlap is there actually in the work they do? So how much wastage and rework is there, in that equation?
Well, that depends on the individuals involved. Some solicitors do a lot of the legwork, and some do no legwork. Some will just get something and send it straight to counsel and ask counsel to do the work for them. Other solicitors will do the work themselves and not involve counsel. Some solicitors will do the work themselves at first instance, then ask counsel to check it. So it depends on the individuals as to the way things play out, and their experience. As I say, you have some excellent practitioners charging, $400-500 an hour, and they do all the work. They may not even use counsel because they're confident in their own skills.
So a practitioner who doesn't use counsel is confident in their own skills, prepares all of everything themselves, affidavit, everything. So I guess, well, solicitor advocate, really.
Absolutely, yes.
And they go toe-to-toe with senior counsel.
I wouldn't say they go toe-to-toe with senior counsel, no. I'd say in that type of matter, then they're probably going to recommend to their client that counsel or senior counsel are engaged.
Do you think that they would do better than a junior counsel?
Possibly, because they may have more experience than a junior counsel.
Okay. So that solicitor advocate, you would say, might be actually not as good as senior counsel, but better than very junior counsel.
I'd say any experienced solicitor is probably going to be better than a very junior counsel.
Okay.
Because experience is very important, and in whatever you're doing, a junior counsel may have only been practicing for a year or two, and this experienced advocate solicitor we're speaking of may have been working for 20 or 30 years. So one would think if they're competent, that their experience would outweigh any benefits in engaging a junior counsel.
I mean, a solicitor advocate you'd think would have knowledge of all the nooks and crannies of the matter.
Absolutely.
And so they have the advantage of doing that. So whereas senior counsel has what? They've got gloss?
Well, senior counsel knows what he or she's given by the solicitor. So the solicitor's got to give senior counsel the information, the evidence, whatever it may be, and then senior counsel, I guess you could say, puts the polish onto those things.
If you have a very low quality solicitor and senior counsel, is senior counsel's performance curtailed by the fact that the solicitor is of lower quality?
I expect that would be the case on average, yes, because at the end of the day, the solicitor has to do the groundwork, whether it be giving counsel or senior counsel the information and documents at first instance, or actioning what counsel or senior counsel want to happen.
Does anyone do this? They just get senior counsel to just do the entire matter, including preparing all the papers?
Generally, no. Senior counsel's not probably going to want to do that. There are counsel that will take on that type of a role. Senior counsel's more, as I say, putting the cut and polish on things, presenting things to the court, and finishing things up. If you want someone to do the day-to-day work, then you may find a counsel that's happy to work that way. Certainly, you almost have to look at it in steps. I mean, your solicitor is step 1, your counsel's step 2, and senior counsel step 3. So it's not often you go directly from step 1 to step 3. Often you need to include step 2 in between.
So let's say you are, someone who's involved in a court case, and it looks like it's becoming very expensive. What can you do? I mean, I'm not talking about, what rights do people have against solicitors. That's not what I'm asking. I'm talking about, is there something you could suggest? I mean, to say, well, maybe this matter could be run more efficiently if we did this or that, or if we ran it in one particular way or another.
Well, it is. I mean, a solicitor should, before he or she undertakes work, should be asking you for instructions if what they are proposing is what you want to do. You're the client, you're the one paying the fees, you're the person that has to give the go-ahead for something to happen. I mean, your counsel or solicitor may want to take your matter in a direction, and you may not want that to happen.
You're not really informed enough to be able to make that decision. If someone says to you, well, maybe we should run this motion or that motion or something, maybe and we recommend you do it and it's a good idea, you might just go, well, that's all the information you have. You still don't know how much the whole case is going to cost you. You don't know how much that motion is going to cost you. They might give you an estimate. But, you don't really know. And you can't really expect that person to be able to foresee, well, if I do this motion, I'm going to be stuck in an interlocutory process or in a quagmire somewhere.
I think it's a matter of, do you trust your lawyer? If you trust your lawyer, then you probably take their advice and you hope that it's good advice. If you don't trust your lawyer, go and get a second opinion.
Well, then it comes to this. If you were to get a second opinion, how do you know that the other person's any better than the guy before?
Well, I don't. You just have to make, the best judgment call that you can. Listen to them, look at them, think about it. Perhaps talk to someone, talk to a friend, talk to a family member. You might know someone that is a solicitor that you can just have a chat with.
This whole process of getting instructions, I've always thought was a cop-out, because I think that the client doesn't know the law or the process as well as the solicitor does.
No.
So the solicitor asking for instructions on what they should do with respect to the law has always struck me as a little bit ridiculous. It struck me partly as a way of them absolving responsibility and saying, well, if it didn't work out, it's actually the client's fault, when it really shouldn't be.
Well, I don't know that it's the client's fault, but a solicitor's, has an obligation to proceed pursuant to his or her instructions.
Do they?
Yes, they do. I mean, if, for example, you went to cost assessment and ran a motion and your client said, I never gave instructions for this motion to be run, well, then you're probably not, the solicitor's probably not going to recover their costs because they've done something without authority.
I understand that, but there's a difference between seeking instructions, which is approval to take a course of action. I can understand that, but you can't. The client needs to be in a position to make an informed decision there.
Yep. Well, you need to ask your solicitor for sufficient information so that the client can make the informed decision.
Well, this is where it comes back to fees and quotes, doesn't it? Because if a lawyer is going to underquote you and continue to underquote you, then each time you take a course of action, you don't have proper visibility of the financial impact on that. You can't make a proper decision. So if we go back to the example, if we went to a car dealership, you wanted to buy a car, and one person says this car will cost you $10,000, another person says it costs you $25,000, you'd say, well, I might go with the $10,000 person. But what if when you go to the $10,000 person and buy it, it turns out that the car needs all these repairs and stuff to bring it to the level of the other $25,000 car, and those repairs are going to cost you $30,000. You're in for $40,000 now. So you don't. It's not an informed type of decision. You can't make an apples for apples comparison there. If the information that you're getting in terms of the financial cost and the expectation there is unknown, and if the lawyer says to you, I don't know how much it's going to cost, I don't know what's going to happen, well, how are you supposed to know if even they don't know?
Well, so if your lawyer gives you that answer, you should look elsewhere.
Well, then it comes back to my first question much earlier, where I was saying we were talking about whether lawyers underquote, and then whether lawyers are capable of quoting more accurately, and you were saying, well, it's not really that possible at the start of a matter.
No, but I mean, if you look at, two things that might play out, well, it could play out this way and that might cost $20,000, and it might play out that way and that might cost $50,000. I think perhaps the lawyer's looking at it playing out this way, and maybe it doesn't play out that way, but perhaps that's what they intended. In a best case scenario, perhaps that's the way the lawyer's looking at the way something may play out. Bit similar to the car. You might go and buy I'm not sure, I think it was a $10,000 car, and that car might be fine. It might just need the brakes adjusted and you're away. You don't know that before you go and buy the car, do you?
Yeah, but you would expect that the person who's recommending that you buy the car would tell you.
You would like to think that, yes.
But in the same analogy, you're saying, well, the person selling you the car doesn't, or recommending that you buy the car, doesn't themselves know if there's something wrong with the car.
Perhaps not.
So why are they recommending this car to you then?
Because it's cheaper. They saw it online, and as far as they're concerned, they've got two cars and they both look the same and they both have different prices. I think most people are going to go for the cheaper option.
So then tell me this, that over all the bills that you've seen, which model consistently produces the least legal cost? Is it the solicitor advocate, or the solicitor who just gives everything to the barrister, or is it someone where they have two lawyers and two barristers working on it? What's the
solicitor advocate tends to be a much more effective legal practitioner and will get you a result quicker and cheaper. And that is reflected by experience. As soon as you add more people into the equation, it automatically costs more money. So if you can find yourself a solicitor advocate, go there.
You think that's the best one?
Absolutely.
And it's always cheaper?
Well, I won't say always cheaper, but I'd say usually cheaper, yes.
Okay, and what's the worst combination?
Well, the most expensive combination is, once you're involved senior counsel, because you've got 3 tiers of legal costs. You've got your solicitors, you've got your counsel, and you've got your senior counsel. So I mean, it's not as simple as saying you're going to pay 3 times as much money, but, that's what you're looking at. So, yeah, I mean, you might need senior counsel because of the complexity of, the evidence or the legal side of it. A very good junior senior counsel will be able to handle most matters. And they're going to cost you less money because there's one less tier involved. There is always going to be an element of duplication between work as soon as you involve more links in the chain, so to speak. That's inevitable because everything goes up and everybody looks at everything. So unless that is necessary, you're better off having less links in your chain.
So let's say a standard link chain might be a junior lawyer, the partner looking at it, then a junior barrister, then a senior counsel, or maybe a senior junior, so to speak.
Okay. First thing I'm going to say, Adam, is I don't want a junior lawyer working on my matter. You might ask me why, because they don't know what they're doing.
Okay.
So that's just going to cost you more money because it's a bit like your solicitor advocate. He or she knows what they're doing, cut straight to the chase. Junior lawyer needs to be told what to do. Don't get me wrong, I'm talking about someone that's very inexperienced. There are, very effective young lawyers out there who are extremely efficient, very low hourly rate, and will get the job done very well. But we're talking about a very junior lawyer.
I'm talking about...
I don't want someone who's had less than, 6 months or a year experience working on my matter.
Well, that's really a graduate. When I say junior, I don't mean someone that young. I maybe meant a solicitor in the office who could be, say, 3 years experience plus, or a senior associate or something like that.
Yeah, some of those solicitors are excellent. And I mean, we've all got to start somewhere. I mean, senior counsel had to start somewhere. The solicitor advocate had to start somewhere.
So let's say I talk about a chain where you have a lawyer with at least 3 years experience, then it goes to a partner, then it goes to a junior counsel, then it goes to a senior counsel or a senior junior or whatever it might be. But that I would consider to be a fairly common chain, because in a firm you might have a lawyer who has day-to-day carriage of the matter that gets reviewed by a partner, and then you have maybe a junior counsel working on it, and then they're assisting a more senior counsel.
Yeah, I mean, a senior counsel is only involved in a reasonably small percentage of matters, so I don't sort of think that example is going to be a common sort of thing. The majority of matters just have one counsel acting. If they're in court, of course, there's not a lot of reason to get counsel involved unless there's some sort of technical advice required in a matter. And they may have that sort of, case law sort of expertise that they can add, or the solicitor doesn't have the experience in the area, so they go and ask counsel, can you please advise me of what is best done to achieve the outcome for the client.
But do you think that there's actually value in having two counsel, like a junior counsel and a senior counsel together, where the junior counsel assists, or do you think that the junior counsel is not necessary? Really, cases should just have one barrister only.
I think that the majority of senior counsel need a junior counsel. So if you have the type of matter that needs or, would benefit from a senior counsel, a junior counsel is sort of par for the course.
Do you really need a solicitor then if you've got a junior counsel and a senior counsel? Because the senior counsel is running the matter, telling the junior counsel what to do. So that's the equivalent of the partner and the solicitor. And the solicitor then is really just sending out letters or paperwork.
Well, no, not it. They may be in some instances, but in the majority of instances, they're doing all the legwork. So they're, speaking with the client, they're obtaining all the evidence, they're doing all the other documentary preparation, putting the, affidavits together, putting all the annexures together, the exhibits perhaps.
That sounds like a clerical task, really.
Well, it's not really. I mean, parts of it are clerical, I agree.
I mean, because if junior counsel is doing the brain part of that, then it relegates the admin part of it to the solicitor, who probably, a secretary or someone could do that. So do you think that chain actually is an efficient chain?
Well, I think it is in the right type of matter, yes, with the right type of, legal people working in the chain. It's a question of each person having defined tasks to do, and then they don't overlap too much. I think that's the secret.
I mean, you sometimes see counsel rewrites a lot of the work of a solicitor. Does that mean the solicitor's work was really wasted and unnecessary?
Possibly. And again, that comes down to the individuals. Perhaps it's the individual solicitor. Perhaps counsel has a certain way they like something to be presented. And if it's not presented that way, then, they're going to change it. Senior counsel perhaps is like that. They tend to be quite direct and specific, and they tend to just, I guess, polish up. But a lot of senior counsel will only use, they like to work with certain junior counsel because their styles are compatible. They like the work that they do, and a junior counsel may provide the right type of preparation that senior counsel is looking for to maximise their efficiency. So they do tend to work as teams a lot of the time. And as do solicitors and counsel, they also work as teams. I mean, if you can find a good counsel to work with if you're a solicitor, well, that's just fantastic because you have compatible styles. You want to work with someone that understands you, and your work's compatible. So you're able to give them what they want, and therefore the duplication between you is minimalised.
Okay. So then let's talk about resolving disputes. And me and you have discussed this many times, but I believe that the only way that you can really settle a matter and settle it efficiently is to just pick up the phone and ring the other side. You think that that's unusual?
I do think that's unusual, Adam. I think that, we've discussed this before, as you mentioned, and you've mentioned, practitioners that are not comfortable picking up the phone and talking. I think that could be a reflection of the times we live in, where people are not as open to communicating with each other. It's a bit like, I play cricket, and people find it odd that you ring them on the phone, because everyone texts, or even texting's a bit outdated now, isn't it? I mean, I'm not sure what the current technology is, whether it's Instagram or Twitter or whatever it might be. But emails now are becoming a little bit out of date. This is amongst the younger generation. So talking on the phone is a bit of an old school type of way of communicating. So in that sense, I don't know that everyone's as comfortable doing that as you may be.
I just don't know if it's possible to resolve something when everyone's a keyboard warrior. I mean, I remember Jeff Bezos made this comment, actually. He said that when he first started Amazon, people would send very rude messages and feedback over email. At that time, it was completely unfiltered. Something happens to people where when they're writing an email or behind a computer screen, they really talk in a different way to how they talk to someone face-to-face or even on the phone. Definitely, I'd say face-to-face brings out the most politeness in someone and brings out the best form of communication. Phone is obviously not as great as that, but it's better than not better than an email. But I think that the problem with emails and letters is you get keyboard warriors. And keyboard warriors, you really cannot, you can't get to the bottom of it. I remember when I was in school, there was this online game that we used to play, and it involved, like, you build your own little kingdom, whatever, and people can attack you and you can attack other people. And this kid in my school sent me all these messages about how he was going to attack me and destroy my kingdom and all that. And he was some, very quiet guy. He doesn't talk to many people, just shy, quiet guy. And I was just so bamboozled by it that when we were at school, I went up to him and said, "Hey, have you got a problem with me?" And he just was terrified. He looked like he was going to go to the toilet and he's going to soil his pants. I mean, I didn't mean it in a way to try to intimidate him or scare him. I was just so baffled that this shy, quiet guy would send such a rude message to someone he doesn't really even know. And so I was thinking maybe I had done something to him and I just wanted to know what it was. And then he said, "Oh, don't worry, I won't attack you, I won't do any of this stuff." It just struck me that, if I communicated him in writing, obviously, I mean, this is just a game, but obviously it wouldn't have been successful. But by talking to someone with a human connection, suddenly they kind of go, yeah, like that's a pretty extreme thing to say to somebody.
Yeah, well, perhaps that medium brings out different people's alter egos, and they can perhaps hide behind the keyboard as such and become a different sort of person. I totally agree with you. Talking to somebody, it's a lot more difficult to say things that, the other person might find offensive, and you're not comfortable doing that. So it's a lot easier to do it through a keyboard. And keyboards, you can also, it probably triggers a different part of the emotional psyche, typing an email or texting perhaps than communicating when you actually have to verbalise whatever it is that you're thinking or feeling. So perhaps that explains why, certain people or perhaps a lot of people in this day and age are not comfortable picking up the phone and having a chat. I remember when I was a boy, the only way you could communicate with anyone was picking up the phone and having a chat. There was no such thing as email or internet or anything like that, so you just didn't have a choice. And I was a lot more nervous, ringing up a girl and talking to her on the phone when I was 15 years old than I would perhaps be these days if I was typing a few things into my phone. I think I'd find that a lot easier than I would picking up a phone, talking to the mum or the dad when they answer the phone, asking permission to speak to their daughter. That was quite nerve-wracking at the time. These days, you just have to, chuck a smiley face to someone and you're away. It's a much simpler way to get whatever outcome you're looking for.
Well, does that mean that when you talk to someone on the phone, they're not really settling with you because they want to, because, their true feelings are reflected in what they write to you?
I think it's quite possibly an alter ego type of situation. Everybody has a lot of different facets to their personality and they're expressed in different ways. And there's only certain people that are able to express verbally everything that they may be feeling or thinking. I think people find it a lot easier to do it via other mediums.
Yeah, I mean, I think, while we do some litigation as well, we do try to settle and do a lot of transactions and deals and things with people. And I think that you really have to have full communication if you can, because I think a lot of communication is actually body language, tone of voice and things like that, which gets lost. I mean, when you write an email to somebody, you could try this one day. I think this checks out. You could have two people writing exactly the same email, and the person who receives the email, let's say for one of the people, they're very close friends, and the other person, they just have a very acrimonious relationship in the same email. And that person who receives it will perceive the two different emails in different ways and the words used in different ways and take offense to the words in different ways. One person is looking and expecting to receive insults, and so they read it into it. And the other person, if they do get joked about, would say, well, this is a close friend, they're probably just joking around with me, and they might even laugh. And so you get that. It actually is very noticeable that the way the email is, just the words then get interpreted based on how the person receiving it perceives the person sending it. So it's not really their message anymore. It's a perception of what their message might be.
I absolutely agree. And everybody has a different perception of most things that might be exactly the same. It's just a matter of how you think and the way you look at something. And as you say, if you're accustomed to having an antagonistic relationship with someone, which, you know, a lot of solicitors are antagonistic with their communications, then that's your starting point when you read something.
Yeah.
And it's entirely different to speaking with someone on the phone.
Yeah. I mean, I that's just been my experience, is that you can get good outcomes just by talking to people.
Yeah, no, I think you're very good at it, Adam. I mean, I've listened to a lot of your phone calls, and you're very effective at achieving a good outcome for your clients. Just simply talking to people on the phone. And alternatively, you can send, 20 emails or letters, which, would obviously cost a lot more money than sitting down for 15 minutes and having a discussion on the phone and getting to the root of a problem.
It doesn't tend to achieve anything either. I think when you write, because people, they perceive the writing in a particular way. I mean, even when you have disputes with tax office, if you send them something and they're a little bit, aggravated with you, the way that they read the information is affected by that. They're probably not going to give you the benefit of the doubt. They're probably going to see something in there that's a problem.
Well, I imagine the large majority of things they read are people that are upset.
Yeah.
It'd be a difficult job to do in that sense.
A lot of things are actually perceived. This is the key, I think, that a lot of things end up being perceived by and understood by reference to someone's views of someone. I mean, I've noticed when the tax office thinks that somebody is dodgy, they will read all their communication with the expectation that there's something dodgy in there and they'll find something. Yeah. I mean, it's just how it is.
It's human nature in a way too, as you say. If you already have a perception of what something is, you look at it with that perception.
And the thing is, the remarkable thing about perception is it will check out. It doesn't matter what someone says, it will check out. I mean, if I think, for example, let's say I think you're a bad guy, there's really nothing you can send me that, if I really wanted to, I could perceive anything you do in negative. If you try to ring me, I could say, well, David's hassling me, he's stalking me, he's just trying to make my life difficult. If you send a message like hello, just say hello, I'll say, look at this guy sending these weird messages. Who sends just hello? If you say hi, how are you, or something like that, you could say, well, this guy's knows that I'm in a bad mood because of him, and now he's going, how are you, and he's rubbing it in.
Very true.
Whereas if it's a friend of yours that say how are you, or maybe they're checking in on me, that's very nice. It's just that everything with a negative enough mindset can be perceived negatively. And then what that means is that if you're going to communicate only in writing, you're never going to break through, because there's nothing that you can say that is capable of not being perceived negatively and reinforcing the negative view. Even if you were to say, well, I'm sorry, or something like that, that might go somewhere. But could it also be perceived as sarcastic to someone who really wants to?
Well, anything can be perceived that way, that's right.
And so I'm just saying, like, it might not always be that way, but it's certainly, I would consider that to be a really big problem, which is why I think, the other forms of communication are so important, because once you have tonality, once you have, you can perceive someone's body language and all those types of things, it removes the perception aspect. Because I think when people read something, in order to understand it and interpret it, they're filling in gaps which they're not getting from the non-verbal cues because it's in writing. And those gaps get filled by the person communicating through their body language and the tonality, which doesn't leave as much space for the other person to misinterpret as would just writing.
Yeah, and also if there is a misinterpretation, there it can be sorted out straight away.
That's right.
It doesn't linger, and you don't have to wait a day or two for that person to respond. It's very important.
Yeah. Thanks, David. All right.